Hello everyone, welcome back to our channel Low Point, and this is Anisha Babu. Our previous two sessions were on need for dowry prohibition as well as various laws dealing with dowry prohibition. Today we are dealing with frequently asked question on this topic, and we have our Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to clear our queries. So moving on to our first question. Is dowry different from stridhan?
The word stridhan, stri means woman and dhan means her property. So stridhan means a woman's property. It can be movable property like cash, ornaments, bank deposits, etc. or immobile properties like landed properties, any flat in her name, etc. Now, in dowry also, all these movable property as well as immobile properties are also part of. So basically, the properties included in both dowry as well as in stridhan are one and the same. But the difference is in the mode of acquiring that property. Dowry is any monetary benefit including movable or immovable property demanded by bridegroom's side in relation to marriage. Whereas stridhan is mainly gifts received by a bride from her relatives, parents or from bridegroom's side out of their own free will, and it might have received before marriage, at the time of marriage or after marriage. Stridhan can also include a daughter's share in her family property. Dowry is prohibited in India, whereas stridhan is having a legal backing. Section 14 of the Hindu Succession Act considers stridhan as her absolute property with all rights to sell it, gift it, exchange it, etc. Further, Hindu Marriage Act provides that woman has a right to get back her stridhan, which is in the custody of her in-laws as and when demanded by her. Likewise, Domestic Violence Act, which is applicable to all women irrespective of their religion, states that if husband or relatives of husband refuses or withhold or misappropriates or preventing her from enjoying her stridhan, then it can be termed as an economic abuse, which is a part of domestic violence. It further states that a woman can get back her stridhan from her in-laws' custody as and when she is a victim of domestic violence.
So moving on to our second question. If friends, relatives or parents of bride voluntarily gift article of high value to the bridegroom, then does it becomes a punishable offence under dowry prohibition law?
If parents or relatives of bride gift voluntarily any movable or immobile property to the bridegroom or to the bride out of their free will or out of their love and affection, is not a punishable offence. It is only when groom's side demands money, ornaments, car or any immobile property as a condition for marriage, then demand for dowry is a punishable offence. Further, give and take formalities which the bride's family accepts and gives into, then again giving as well as taking dowry are punishable offences. Unfortunately, many families cover up dowry as gifts and believe that expensive gifts and lavish weddings will bring respect for bride at her in-laws' house. It is important to note herein that under the Dowry Prohibition Act, gifts given to bride and groom at the time of marriage should be compiled into a list which will ensure that women can lay claims on this gift as and when need arises.
So let's take a quick dive into our next question. Even after parents bid farewell to their daughter, giving her dowry in cash or in kind, then such a daughter can lay claim on her parents' property if parents die without leaving behind a will?
Even after receiving dowry, a married-off daughter still has equal right as that of a son to succeed in her parents' property. We have seen in our previous session of interstate succession of Hindus, Christians, Muslims that if parents die without leaving behind a will, a daughter is equally entitled to inherit her parents' property as that of a son. irrespective whether she is married or not, or whether she has received dowry or not. She has every right to inherit the same. It is her absolute property and she can choose whether to sell it, gift it, mortgage it, etc.
The last and the final question. Under Muslim law, what is mahar or dawar and how is it different from dowry?
Mahar or dawar is a concept in Muslim law. For Muslims, marriage is considered as a contract and mahar or dawar is a specified amount or any benefits or any property that a wife is entitled to collect from her husband as a consideration of marriage. The object behind providing mahar is to enable independence of wife. So, there is an essential difference between dawar under Muslim law and dowry. Dowry is any monetary benefit or any property demanded by bridegroom side to bride side. Demanding dowry, giving dowry and taking dowry are all punishable social evils, whereas mahar or dawar is permissible in law. And if a husband intends to divorce his wife, then first he has to return her mahar or dawar. Mahar or dawar provides financial security to a wife during and after marriage.
Thank you for watching. This brings us to a close on the dowry laws. See you next week with another legal topic. Till then, take care. Bye-bye.